Let's talk about homeowners associations. You know, for some people, they're great for keeping property values up. For others, well, it can feel like a constant battle. Today, we're getting into the story of one homeowner who got into it with his HOA, but instead of just giving in, he decided to fight back, using the most powerful tool he had, the law itself. I mean, have you ever felt that way? You get a notice or a fine, and you just think, wait a minute, can they even do that? Sometimes it's just disorganization, but sometimes it really feels like a power trip. Well, this story is a fantastic reminder that you as a homeowner absolutely have rights and your HOA has laws they have to follow. Let's dig into how one guy proved just that. All right, so our story kicks off in Tucson, Arizona, in a community called Saguaro Crest. We meet our homeowner, Clifford Burnes, who, by the way, goes by Norm. He just decided he needed to see some of his HOA's records. Nothing dramatic, just a simple, formal request. Okay, this is where it gets really interesting, because Norm was super deliberate about this. He sent a certified letter and an email. He made it perfectly clear he wanted copies of the documents, not just to pop in and look at them. He even offered to pay for them. Right from day one, he was building a solid paper trail, all based on state law. And this right here, this is the heart of the whole thing. The law in Arizona is crystal clear. This isn't just a suggestion, it's not a guideline, it is a hard deadline. The moment that request for copies lands, a legal clock starts ticking. 10 business days. That's the law, and that's the foundation for this entire case. So you've got a clear request and a clear law. Should be simple, right? Yeah, not so much. What should have taken 10 days turned into a 2-month-long saga of pure frustration. So how did this spiral so out of control? Well, the timeline really tells the whole story. Just look at this. The request goes in on New Year's Eve. That 10-day deadline should have been up around mid-January. Instead, the HOA's first response goes to a completely wrong address. By the time he actually gets the right documents in his hands, it's the end of February. That deadline wasn't just missed, it was completely ignored. So, you see, it wasn't just one little mistake. It was a whole series of them. You've got basic stuff like mailing things to the wrong house. Then they throw up roadblocks insisting he come in for an inspection he never even asked for. And then the whole name mix-up, they couldn't even get his legal name right for certified mail. It felt like at every single turn, there was a new, totally avoidable problem. So after almost 2 months of this back and forth, Norm had had enough. He filed a formal petition, and the whole thing went to an administrative hearing. This is where it gets serious. Both sides have to lay all their cards on the table right in front of a judge. And the arguments were just worlds apart. On one side, you have Norm sticking to the facts. The law says 10 days for copies, end of story. On the other side, the HOA's defense was, let's just say, creative. They claimed their process was more efficient for them, that they acted in good faith, and they even tried to blame Norm for the mail problems because he goes by a nickname.
But here it is. Here's the kicker. During the hearing, the HOA's own lawyer had to admit that, yeah, they had a member list the whole time. A list with Norm's correct legal name, Clifford, and his correct address. That one little admission just completely blew up their whole argument that he was somehow to blame for their mistakes.
So with all the evidence out there, it was time for a decision. And let me tell you, the administrative law judge, Jenna Clark, she did not mess around. Her verdict was just a masterclass and getting straight to the point. This sentence says it all. The judge basically said, nope. An HOA can't just make up extra steps like forcing you to come in for an inspection if the law doesn't say they can. A homeowner's right to just ask for copies is protected. That whole efficiency argument from the HOA, legally, it meant nothing. So, the bottom line, it was an absolute, clear-cut win for the homeowner. The judge found that Norm had proven his case, and the Saguaro Crest HOA had without a doubt broken the law. A total victory. And it wasn't just a moral victory either. It came with a real result. The judge ordered the HOA to pay Norm back his $500 filing fee. So not only did he prove he was right, he got his money back for having to hold them accountable in the first place. Look, this isn't just some story about a guy in Arizona. This is a case study with huge lessons for anyone who lives in an HOA community. So let's break down what this means for you. The biggest takeaway here is that knowing your rights is your best weapon. You have a legal right to see those records. Your HOA has to follow firm legal deadlines, and they don't get to add extra hoops for you to jump through just because it's more convenient for them. Their convenience does not get to trump your legal rights, and, most importantly, there are official ways to fight back if they don't comply. So, if you ever find yourself in a spot like this, here's your playbook. Step 1. Know the law in your state. A quick search can tell you a lot. Step 2. Document everything. Create that paper trail just like Norm did. Step 3. Be persistent. As we saw, they might drag their feet or make mistakes, but don't you give up. And finally, if they still won't listen, don't be afraid to use the formal process. It's there for a reason. And that really brings us to the final thought here. Norm's story shows that one person who knows their rights and is persistent can absolutely win against an HOA that's overstepping. It leaves us all with a pretty important question to ask. Does your HOA really understand and respect the law? Because as this case proves, those laws are definitely not just suggestions.